Did you look into it?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer, and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer.
On September 8th, 2025, Christopher Harris appeared before Judge Stevens in Jefferson County, Texas, for a bond hearing that would determine whether he would remain free while awaiting trial on 2 serious felony charges. What made this hearing particularly remarkable was the sheer audacity of the conduct that brought Harris back before the court. Just weeks earlier, Harris had been arrested on charges of aggravated assault with a deadly weapon after allegedly shooting a man 6 times in his lower extremities on July 19, 2025, on East X Freeway in Beaumont, Texas. The court had set a $250,000 bond on those charges, a substantial amount designed to ensure Harris would appear for trial, while also reflecting the serious nature of the allegations against him. Harris's mother had come forward and posted that bond, putting up $50,000 of her own money to secure her son's release from custody. It was an enormous financial sacrifice, the kind only a parent would make for a child they believed in. But Christopher Harris would repay his mother's sacrifice in the most devastating way imaginable. Rather than staying out of trouble, attending his court dates, and demonstrating to the court that he deserved the freedom his mother had paid dearly to obtain, Harris allegedly went right back out and committed another violent crime, this time an armed robbery, while wearing a GPS ankle monitor that tracked his every move. And as if that wasn't brazen enough, he allegedly posted the stolen jewelry on his Instagram account for the world to see. By the time Harris appeared before Judge Stevens on September 8, 2025, the question was no longer whether his bond should be increased. The question was whether any amount of money or any monitoring condition could protect the people of Jefferson County from a man who appeared completely undeterred by the consequences of his alleged actions.
Who posted your bond? You had a bond when you were arrested for $250,000? Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
My mom was size.
It's 5, so she posted $50,000. Okay. There's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all? I can see you don't seem real upset about it. It would be for me.
The $50,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is...
Looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault. And there was a bond set of, looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right? So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting, and the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled, and so a $250,000 bond was set in that case.
The judge methodically walked through the details of the first case against Harris, the aggravated assault charge stemming from the July 19, 2025 incident. According to the probable cause affidavit, police responded to East X Freeway in reference to a shooting victim who was suffering from multiple gunshot wounds to his lower extremities. The evidence indicated that Harris had entered an unlocked apartment, produced a handgun, fired 6 shots at the victim causing serious bodily injury, and then fled the scene. These facts form the basis of the aggravated assault with a deadly weapon charge. Under Texas Penal Code Section 22.02, aggravated assault is committed when a person intentionally, knowingly, or recklessly causes serious bodily injury to another person or uses or exhibits a deadly weapon during the commission of an assault. When a deadly weapon such as a firearm is used, the offense is elevated to a first-degree felony, punishable by 5 to 99 years or life in prison, and a fine of up to $10,000. The decision to set bond at $250,000 reflected the serious nature of these allegations. Under Article 17.15 of the Texas Code of Criminal Procedure, judges must consider several factors when setting bond, including the nature of the offense, the circumstances under which it was committed, the ability of the accused to make bond, the future safety of the victim and the community, and the defendant's criminal history. A $250,000 bond signals that the court viewed Harris as both a potential flight risk and a potential danger to the community. The additional requirement of an ankle monitor was an extra layer of supervision designed to track Harris's movements and deter him from engaging in further criminal activity. As would become devastatingly clear, neither the bond amount nor the ankle monitor accomplished either of those goals.
Just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th, 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont with the lights on and the engine running. And observed someone named Arthur Goolsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant, Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You have 3 people at gunpoint and then steal everything, tell them to run and then shoot at them. Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And we'll put him right at the location at the time of the robbery.
Just 5 weeks after allegedly shooting a man 6 times and posting a $250,000 bond, Christopher Harris allegedly participated in a brazen armed robbery on August 25, 2025 in Beaumont, Texas. According to the probable cause affidavit, Harris and 2 accomplices, Arthur Goolsby and Brandon Johnson, lured a victim named Wilson into picking them up under the false pretense of going to a party. Once in the vehicle, they directed Wilson to a secluded area where Johnson asked Wilson if he could drive. When Wilson pulled over, Harris and Johnson pulled out handguns and robbed Wilson at gunpoint, stealing his silver necklace, watch, cash, and his Lincoln Navigator. They then told Wilson to run, and as he was fleeing for his life, Johnson shot at him. All 3 suspects then fled in Wilson's stolen vehicle. Under Texas Penal Code Section 29.03, aggravated robbery is committed when a person commits robbery and causes serious bodily injury to another, uses or exhibits a deadly weapon, or causes bodily injury to, or threatens or places in fear of imminent bodily injury, an elderly or disabled person. Aggravated robbery is a first-degree felony in Texas, punishable by 5 to 99 years or life in prison and a fine of up to $10,000. The case against Harris was extraordinarily strong for multiple reasons. First, his co-conspirator Arthur Goolsby was apprehended at the scene, still in the stolen Lincoln Navigator with the lights on and the engine running, and immediately confessed to his involvement, naming Harris as one of the armed participants. Second, and most remarkably, Harris's GPS ankle monitor placed him directly at the robbery location at the exact time the crime occurred. The very device designed to monitor his behavior and deter future crimes had instead become ironclad evidence of his alleged participation in an armed robbery. As the judge noted with barely concealed disbelief, when you got an ankle monitor and you're going to be tracked, why would you be around someplace that causes trouble? It was a question that defied rational explanation, but perhaps most damning of all was what investigators found on Harris's social media account.
And so, if that's not enough, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry that was stolen from the robbery. Okay. There is a motion to increase the bond. Anybody else want to be heard? I've read it, the 4 corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the ruling. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the $500,000, which he has not made. So I'm asking the court to keep both cases at the $500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that $500,000.
Anything? Statements?
Your Honor, we're just asking for the other one is at $500,000. We've just asked for the $900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into it, bro?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer, and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise.
The final piece of evidence presented by the court was arguably the most stunning. An Instagram account belonging to Harris contained a video of him wearing jewelry that had been stolen from the robbery victim. This single piece of evidence transformed what might have been a circumstantial case into a virtually airtight prosecution by By posting stolen jewelry on social media, Harris had essentially confessed to the robbery on the internet for anyone with an account to see. This kind of social media evidence has become increasingly common in criminal prosecutions and has proven devastating to defendants. Under Texas Rules of Evidence Rule 901, digital evidence including social media posts can be authenticated and admitted into evidence when there is sufficient proof that the account belongs to the defendant and that the content is genuine. Courts across the country have consistently upheld the admissibility of social media evidence in criminal cases, recognizing that defendants who post incriminating content online cannot later claim the evidence is inadmissible simply because it originated on a social platform. The defense attorney's response to all of this evidence was notable for its restraint. Rather than making dramatic arguments or challenging the evidence head-on, the defense simply asked the court to maintain both bonds at $500,000, pointing out that since Harris had already made the $250,000 bond on the first case, but had not made the $500,000 bond on the second case, the court had effectively already doubled the bond amount. The defense was essentially conceding that an increased bond was appropriate while trying to prevent the court from going even higher. The prosecution, on the other hand, asked for a bond of $900,000 on the aggravated assault case, arguing that the nature of the offenses, particularly the fact that Harris had allegedly committed an armed robbery just weeks after being released on bond for allegedly shooting someone 6 times, justified a dramatically increased bond. During these arguments, Harris apparently attempted to communicate directly with a court officer, which prompted a sharp rebuke from the judge. "You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer. You can be your own lawyer. Is that what you want?" The judge's rhetorical question, "That would be wise," when Harris declined to represent himself, was dripping with sarcasm, suggesting the judge had already made up his mind about what was going to happen next.
Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot.
No contact with complaining with witness remain in Jefferson County and to testifies.
Okay. So, just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring him, did not deter him from committing a more violent crime. So he is in custody and there is no bond.
Judge Stevens' ruling was comprehensive, methodical, and absolute. He began by reviewing the conditions of the original bond on the aggravated assault case, noting that not only had a $250,000 bond been set, but Harris had also been required to wear an ankle monitor as an additional condition of his release. These were serious, substantial conditions that reflected the court's recognition that Harris posed a risk to the community. And yet, the judge noted, in spite of all of that, Harris had defied logic by committing another violent crime while wearing the very device designed to track his movements. The judge stated plainly, "It's obvious that the conditions of bond that were set, a high bond amount and an ankle monitor monitoring him, did not deter him from committing a more violent crime." Under Article 17.152 of the Texas Code of Criminal Procedure, a judge may deny bond entirely if the defendant is accused of a felony committed while on bail for a prior felony, and the judge finds that no conditions of release would reasonably ensure the safety of the community. This provision reflects a fundamental recognition that some defendants pose such a serious and ongoing threat to public safety that no amount of money or monitoring can adequately protect the community. The judge found that Harris met this standard precisely because the case before him demonstrated that even the most stringent bond conditions, a $250,000 bond plus GPS monitoring, had failed to prevent Harris from allegedly committing another violent armed crime. His ruling was unequivocal. There is no bond. The court finds that there are no reasonable conditions that can protect this community from this bizarre violent crime need. Furthermore, the judge revoked the original $250,000 bond that had been posted on the aggravated assault case. This meant that the $50,000 posted by Harris's mother was gone, forfeited to the court because Harris had been arrested for a new offense while out on bond. Under Texas law, specifically Article 22.13 of the Texas Code of Criminal Procedure, a bond is forfeited when the defendant commits a new offense while released on bail. The forfeiture of bond is not a punishment imposed on the person who posted the bond. It is an automatic legal consequence of the defendant's breach of the conditions of his release. But the practical effect was devastating. Harris's mother had lost $50,000 because her son had allegedly gone out and committed an armed robbery while wearing an ankle monitor.
The court finds that there are no reasonable conditions that can protect this community from this bizarre, violent crime need. And for the protection of the people and to see that the Constitution works so that we can live in peace, the defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost unfortunately to his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem too upset, but there are victims in two different situations, but there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay? All right. That is all.
Judge Stevens concluded the hearing with remarks that were as legally precise as they were personally pointed. Addressing Harris directly, he observed that Harris didn't seem upset, not about being held without bond, not about facing the prospect of spending years in prison, and not about the fact that his own mother had just lost $50,000 because of his alleged actions. Ironically, you don't seem too upset, the judge said. But there are victims in two different situations. But there's also a victim here, your own mother, that you victimized by your actions. The judge's observation cut to the heart of what made this case so morally troubling. Christopher Harris had not just allegedly victimized strangers, H.E. had also victimized the person who loved him most, the person who had put up $50,000 of her own money because she believed in him, because she wanted to help him, because that is what mothers do. And Harris, according to the judge's observation, didn't even seem bothered by it. This case illustrates several critical principles about the American bail system and the consequences of reoffending while on bond. First, bond is not simply a get-out-of-jail card. It is a legally binding agreement between the defendant and the court that the defendant will appear for all required court proceedings and will not engage in criminal activity while released. When a defendant violates those conditions, particularly by committing a new violent offense, the consequences are severe and far-reaching, affecting not just the defendant, but everyone who put their faith and finances on the line to secure his release. Second, the modern combination of GPS monitoring technology and social media has fundamentally transformed the evidentiary landscape in criminal cases. Harris allegedly committed an armed robbery while wearing a device that tracked his every movement, and then allegedly posted stolen jewelry on Instagram for the world to see. These two pieces of evidence alone, his GPS location data and his social media post, placed him at the scene of the crime and connected him to the stolen property in ways that would have been impossible to establish just 2 decades ago. Defendants who believe they can commit crimes while wearing ankle monitors or who post incriminating content on social media are not just brazen. They are providing prosecutors with some of the strongest possible evidence against themselves. Third, this case demonstrates the legal concept of dangerousness as a basis for pretrial detention. The 8th Amendment to the United States Constitution prohibits excessive bail, but the Supreme Court established in the 1987 case of United States versus Salerno that preventive detention, holding a defendant without bond based on their danger to the community, does not violate the Constitution when appropriate procedural safeguards are in place. Texas law specifically provides for no bond holds in cases where the defendant commits a new felony while released on bail for a prior felony, and Judge Stevens applied this provision based on a thorough and well-reasoned analysis of the evidence before him. The broader lesson of this case is sobering. Christopher Harris had been given an extraordinary opportunity. His mother had sacrificed $50,000 to give him his freedom, and the court had trusted that the combination of a high bond and electronic monitoring would be sufficient to protect the community while his case proceeded through the courts. That trust was betrayed. The shooting victim on East X Freeway, the robbery victim whose car and belongings were stolen at gunpoint and who was shot at as he ran for his life, Harris's own mother who lost her savings, all of them paid the price for Harris's alleged choices. As Judge Stevens made clear, there comes a point where the court has exhausted every reasonable option to balance a defendant's liberty interests against the community's right to safety. When that point is reached, the Constitution and the law provide a clear answer. The community's protection must come first. Christopher Harris will remain in custody without bond until his cases are resolved, and his mother's $50,000, spent in an act of parental love and faith, is gone. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.